without further ado, I mean, if you got questions, we'll get to them. I'm not sure how long it's going to take. How many pages? 17 pages? That probably takes like 20 minutes, half an hour. What do you think? Oh, Rosa's in here. Fantastic. So if I get things wrong, Rosa can just go, "You're wrong." Pop that in the chat for me, and we'll find out exactly when and where I was wrong on things. But without further ado, the document of the week here. Boom. All right. Here we go. They have really convoluted case numbers in federal court, don't they? All right. Here, Roza opposes defense motion to dismiss. In support of her opposition, plaintiff states as follows. As of the date of this filing, 60 days have lapsed since the defendant halted trading on the Meta Series A preferred share, MMTLP, and not a single shareholder has received Nextbridge hydrocarbon shares. On February 6, 2023, CEO Cromwell Coulson of the OTC markets, where MMTLP was being traded, tweeted from his verified account, "There was a short position on MMTLP. The data reference comes from a twice-a-month OTC equity short interest on FINRA website." Coulson continues in his thread by urging that it would be easier if Nextbridge shares became publicly tradable. The short position Coulson commented on is the reason plaintiff and her class of shareholders have yet to receive Nextbridge hydrocarbon shares. Boom, right out the bat, pointing out the short shares that it seems that FINRA keeps wanting to ignore. That the OTC market, the CEO of the OTC has stated that that happens. FINRA's own website shows the short volume. And the reg show thresholds list shows a whole bunch of FTDs. So boom, there's three things right there that back up Rosa's entire argument. So hitting a home run right at the bat. That sucker is like a punch to the nuts for FINRA. Short positions are contracts to borrow shares from shareholders to be returned at a later date. Private companies are not eligible for shorting, and thus Nextbridge hydrocarbons cannot carry short positions. All short positions must fulfill their contract with the shareholders before the private company Nextbridge hydrocarbons can issue the one-for-one exchange. The CEO of the OTC markets has confirmed on a public platform that the defendant has not enforced the contract. The contracts be fulfilled at the expense of shareholders. Oh, delicious. So good. The method suggested by the CEO of OTC markets, who has a financial interest in reducing obligation for holders of short positions, will, 1, not require short positions to close their contractual obligations, because short positions can be held on public companies, thus benefiting parties acting in concert, and 2, violate the intent and mission of Nextbridge Hydrocarbons, a public reporting private company. Oh, so good. As it stands, shareholders cannot hold a shareholder meeting, hold an emergency meeting, or seek direction from a board of directors because shareholders cannot be ascertained. So the powers are supposed to be granted to you via having your shares, you cannot have because no one has the shares. Right? We haven't received them yet. Woo! That's another subtle way of saying there's an injury. I think she's just warming up here. Oh, it's a beautiful read. Short positions are contracts to borrow and return a share at a later date. Precluding short positions from fulfilling the obligation of returning the shared stock is taking, and failure to regulate the short positions that are unreturned after over 45 days of failures to deliver is an act in concert to dilute private company Nextbridge Hydrocarbons, over which defendant has no authority. There you go. All right. So basically she's saying that the halt destroyed the ability of short sellers to close their positions, and in doing so help them. So that is not their job. Their job is not to help short sellers. That is not part of their purview. Their purview is to make sure there's no shenanigans in the market instead of promoting the shenanigans. Okay, a 12B6 motion. What was the court rule? 12B6, I presume, civil rule. Motion tests whether the plaintiff has pled a cognizable claim. See Sheed versus Fandy Farmer Candy Shops, blah, 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 blah. A court is to presume well-pled allegations are true, resolve the doubts and inferences in favor of the pleader, and view the pleading in the light of the most favorable of the non-moving party. And then another citation. A complaint. So this is talking about her motion to reconsider that they're opposing, and how the court is supposed to approach this. A complaint should not be dismissed for failure to state claim unless it appears beyond doubt that the plaintiff can prove no set of facts in support of his claim which would entitle him to relief. Therefore, the standard applied in evaluating motion to dismiss. This is refers to a motion to dismiss, not her. Their motion to dismiss. Standard applied in evaluating a motion to dismiss is very liberal in favor of the party opposing the motion. See blah 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 blah. When a defendant alleges Article 3 standing, the plaintiff is protected by safeguards similar to a Rule 12b-6 motion to dismiss for failure to state a claim. The court must treat the factual allegations in the complaint as true. Another citation. The U.S. Supreme Court has directed the court to be mindful that, at the pleading stage, general factual allegations of injury resulting from defendant's conduct may suffice. Basically, because Roza stated that she was injured by these actions, that should be enough to keep the case from being dismissed. The court must presume that general allegations embrace those specific facts that are necessary to support the claim. Basically, she presented some evidence. She showed how she was injured. Therefore, the standard for the court must be we move on. The court should not dismiss a case unless satisfied that the complaint cannot state any set of facts that would entitle the plaintiff to relief. Meaning, if they cannot say that her injuries weren't injuries, right? So if she says, "Hey, I was injured by FINRA, and these are the reasons why," and none of their filings in their motion to dismiss show that she wasn't injured in that way, then they can't dismiss. I mean, like, if you're going to dismiss something, it'd be, I was late to work this morning because I was laughing too hard at the morning DJ saying something, and I got into an accident, and I'm going to sue the DJ for being funny, right? The court is going to throw that case out. The DJ had nothing to do with you not paying attention to the road. You could easily, if you were, laughing too hard, you could pull over, and you've got your own ways of solving that problem. So Roza's saying, no, I was injured. These are specific ways of injured by this action. You can't dismiss because they can't show that I wasn't injured in this way. Argument. Article 3 standing. The Honorable Court in the Northern District of Florida can't read apparently. The Honorable Court is in the Northern District of Florida and has the right to hear federal questions, Sherman Act claims, and federal questions. Sherman Act claims are federal questions. 15 U.S.C. 1, the defendant makes a sweeping allegation that the plaintiff lacks Article 3 standing by claiming that private persons should be able to monopoly with no avenue for recourse or judicial intervention, when in fact Congress passed Section 5A of the Clayton Act intending to give the private litigant as much aid in establishing a violation of the antitrust laws as was then perceived to be possible under the Constitution. The use of government judgment in private antitrust litigation, Clayton Act, blah, 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 collateral estoppel and jury trial. The right of action under Article 4 of the Clayton Act Section 4. I can't remember if that means article or section. The Clayton Act is available only to private plaintiffs who have suffered antitrust injury. Bam. The defendant further argues that because the subject matter at issue is within the SEC's regulatory purview, this court lacks jurisdiction. A district court lacks subject matter jurisdiction to hear claims when Congress creates a comprehensive regulatory scheme from which it is fairly discernible that Congress intended the agency expertise will be brought to bear prior to any court review. We do not think, however, that Congress intended for the SEC to adjudicate claims such as the ones at issue here. A private cause of action for fraud under 10b Rule 10b-5 emphasis added. The defendant has not pointed to any language in the Exchange Act. The evidence is such an intention. Our interpretation of the Exchange Act in this case would not interfere with the administrative process because meritorious private actions to enforce federal anti-fraud securities laws are an essential supplement to civil enforcement actions brought by adjudicated by the SEC. Basically, the SEC can step in and do this role, but that's not the only ones who can step in and do this role. The courts can as well, via a lawsuit like this. So sometimes regulators don't catch everything, and sometimes you get sued for it. Okay. Although the Exchange Act does not expressly provide for a private cause of action for 10b violations, ever since our decision in Fishman versus Raytheon Manufacturing Company, we've held that 10b provides such an implied right. Thus, a private plaintiff can recover on an antitrust claim for loss which stems from a competition reducing aspect or effect of the defendant's behavior. Okay, so Roza can sue because of their behavior. That's pretty simple. Absolute immunity is rare and exceptional in character. The defendant serves two functions. One, as a self-regulatory organization to promulgated and enforce rules governing the conduct of its members, and two, as a billion-dollar private investment organization whose net income in 2021 was $1.4 billion, with 90% of assets being cash and investments, and whose CEO received a salary of $3.12 million in 2020. Because of the duality of the function of regular agency and private business interests, such as investment interest in trading volume and market activity, courts should review the pertinent conduct and determine whether the conduct was protected by immunity claims. Basically saying, if there's immunity, it's probably immunity for something specific, and the court should look at whether this fits that role of the specificity of the immunity. Courts must examine the invocation of absolute immunity in a case-by-case basis. There you go. Given the significant protection, courts have cautioned that the doctrine of a rare and exceptional character, Barrett v. United States, until shareholders can be ascertained to exercise shareholder rights or reconciliation occurs, shareholders are deprived and no remedy is available. To deprive shareholders of judicial remedy will be an extreme use of the doctrine. So basically, you can't give them immunity because there is no recourse other than this lawsuit currently, because they've been injured. All right. When exchange engages in conduct to operate its own market that is distinct from its oversight role, it is acting as a regulated entity, not a regulator, as found in Amerivet Securities Incorporated v. FINRA. This is the one that Amerivet was able to win and force FINRA to give them all the documents they wanted. In order to determine whether the defendant was acting in their official capacity or as an investor-regulated entity working in a concerted effort to suppress the fulfillment of contractual obligations of shareholders, an accounting must be furnished. So she's asking, show me the numbers. Give those numbers to me. And if they have to give the numbers to her, then they don't have the immunity that they claim, right? Claims are not moot until Nexbridge is issued to shareholders. The defendant claims that plaintiff's claims are moot. However, MMTLP has not been deleted, and there has not been a D1 issuance to delete the symbol. The defendant obfuscates as to the meaning of the deletion when provides false information regarding the status of the symbol. This is where FINRA and all of their documents so far have said they deleted MMTLP. We deleted it on the 13th. It doesn't exist. It's gone. And when you go look, it has not been deleted, and the halt still exists. Right? So they lied in their documentation to the court. Motion to dismiss, number page 22. So she's citing the page that they make this lie on. If one makes a call to FINRA headquarters upon request, they will share that the symbol has not been canceled. A D1 is issued with the deletion of a symbol. However, due to the inability to reconcile MMTLP, it cannot and has not. Plaintiff implores this court to inquire independently, as the symbol cannot be deleted because the defendant has protected their own investments and acted in concert with investing parties seeking independent financial interest. The defendant further obfuscates, as it indicates the defendant simply reviews company requests as if documents are not deemed deficient, publishes corporate actions, motion to dismiss, page 22, or number 22, page 10. When in fact the defendant sets the ex-dividend and effective dates. Boom. There's a nice little hot account for you. Hot link. When the defendant was aware of the outstanding short positions, the failures to deliver, and was in control of the ex-dividend and effective dates, they acted to shield parties holding short positions in investment conglomerates such as their $1.4 billion investment assets at the expense of plaintiff and shareholders of MMTLP. A case is moot when the issues presented are no longer live or parties lack a legally cognizable interest in the outcome. The defendant has not deleted the symbol, and the exchange process has not been resolved due to the unreconciled outstanding short contracts acknowledged by the CEO of the OTC markets, where the symbol was trading until the defendant's halt. Until shareholders can be ascertained to exercise shareholder rights, or until Nexbridge Hydrocarbons has been issued, the case and controversy is very much alive and requires judicial intervention to protect plaintiff the protection of plaintiff shareholder due to the lack of transparency from the defendant's actions as an investor and a regulated entity. So basically, she's throwing down, and Rosa's probably in here going, "Yeah, I'm throwing that down." She's throwing down that FINRA operates in two roles. One, they are a regulator, and two, they're also a participant. And if those roles cross, and they are using the regulatory power to protect their role as a participant, then they're really screwed. The foregoing reasons, plaintiff respectfully requests this court to deny defendant's motion to dismiss. Submitted, blah, blah, blah. Okay. And then we've got the Emirates Securities Incorporated order showing that FINRA had to pony up all that stuff. That was actually, a lot of these pages are the Amerivet one. Okay. DC Attorney acknowledges that whenever possible, a question of absolute immunity should be determined on the outset of the litigation. Okay. These courts also recognize, however, that sometimes discovery will be necessary and helpful in making this determination. So in order for them to even determine if they've got immunity, they're still going to have to follow through and provide the data that she's requesting. That was quick. That wasn't too painful. We got through that sucker. All right. Yeah. Boom. So we've got court precedent, and she's got it on her side here.